the accused person. I want to hear your thoughts on the rules of fair trial and bail conditions, which some of us deem too onerous.
Is that I'm the last, I'm your ranking, I'm the last to ask. So you, if he wants to ask, let's allow him to ask his questions.
Honorable Ranking Member, at the moment, I am the chairman of this committee, and I'm the last person.
Is that I'm the last, I'm your ranking, I'm the last to ask. So you, if he wants to ask, let's allow him to ask his questions.
Honorable Ranking Member, at the moment, I am the chairman of this committee, and I'm the last person to speak. So I indicate who speaks next. You are on the floor. Thank you.
Want your voice to be?
All right. At least what you've just said has become part of our records. A good precedent, no problem. You, when I'm done, just call the majority leader to do his re-examination, no problem. Honorable nominee, we did some checks based on your own CV you brought to us. I want you to clarify for the record. Where did you do your national service?
I did my national service after A level at Kangbili JSS, Kangbili Junior Secondary School. Yes. In the Western region. The Western region.
Very well. My lady, please, in your time after doing your national service, are you issued with a certificate? During those periods, were you being issued with certificates?
I did not get a certificate. I did not get a certificate when I finished. I am sure I could have applied for a certificate, but I did not get a certificate, yes.
The reason I ask you, in all fairness, is because national security got back to us that they have no such records of you having done your national service at Kangbunli JHS in Western Region. That's why I wanted you to clarify. Because
I did.
Very well. So you may have to furnish us with some other details you have later, not now, just to confirm. All right. Now, what is your age now, please?
I'm 52 years old. 52 years old.
Very well. So, what it means is that if the opportunity avails itself, you would have some 18 years to serve on the bench.
That is correct.
My lady,
Yes.
I intend to take your thoughts on Articles 286 and 287 of the Constitution. I would preamble what I'm going to say. With recent decisions of His Excellency the President regarding imposition of salary fines on ministers and appointees who fail to declare their assets. I shall also want to know your mind on the exclusive role of SHRAJ in investigating breaches of asset declaration obligations. That said, as a background, I proceed to ask you One, in your view, do you think that the president has a constitutional authority to impose sanctions, such as fines on ministers and other appointees who fail to declare their assets? Or, to you, this function is exclusively reserved for shroud under Article 287 of the Constitution?
I believe that the office of the president has decided to put in place some administrative procedures. And I do not see that there is a conflict with the duties of SHRAJ. Because if a public officer is reported to SHRAJ as having contravened the law on filing of the necessary documents or declaring assets, SHRAJ would also be entitled to take its necessary action. So I do not think that there is a conflict between the two.
My lady, that said, let's stay a bit on what you describe as the administrative decision. So that is at the heart of my question. Are you therefore suggesting that in spite of that constitutional mandate given to SHRAJ to investigate and make appropriate orders or recommendations, sanctions, etc., administratively, the president, in the exercise of his executive functions, can also impose sanctions, fines, as is the case?
Honorable Chair, I would like the question to be repeated.
So, what I'm saying is that the Constitution mandates SHRAJ to take up matters regarding breaches of the Constitution in the manner that I've already given a background to. And I'm giving you an example of asset declaration. Failure to declare your assets. I am referring to the recent administrative directive by the president to sanction those breaches by way of a fine. In that context, I want to pick your thoughts on whether or not administratively His Excellency can usurp such powers to impose administrative fines as part of his executive powers.
Thank you, Honorable Chair. I do not think that it's a usurpation of powers. That is my position.
Very well. But administratively, Chairman, this strategy by the majority that they have their time, when it gets to my time, then I have follow-up. Anyway, I will yield to you. If you, Chairman, would want to allow these things, no problem. Follow up. And you think that you'll be distracting me. I don't have...
Honourable members, I believe everybody must be treated equally, particularly the leaders. There are instances where the minority leader called for a follow-up question and he's been granted the floor to ask a follow-up question. In all the vetting that we've carried out, the record can bear me out. So if the majority leader wants a follow-up question, I think it is in good faith that we ask him to do a follow-up question. Please, Majority Leader, you have the floor.
Well, this being the first time I'm speaking, let me join colleagues to congratulate my 1 year
Mr.
senior.
Mr. Chairman, let's be careful what we are doing. It's not good for democracy. If it's a follow-up, let me congratulate my 1 year senior. If it's a follow-up, you should go straight to the chairman. Don't be doing these things. So it may be politically convenient for you, but tomorrow it will hit us as a parliament.
I can just understand the minority leader this afternoon. Because if the person going to ask the follow-up question is now talking to the nominee for the first time, what is wrong?
But he would have the opportunity to ask his own substantive questions.
So
He's already indicated to the deputy chair that he will take his turn after me. Please, let us not set a bad precedent. This is not the first time we are doing vetting. Let's stop this. You are the majority. You may not want to delve deeper. Allow us to do our work. What is happening is not good, Mr. Chairman. When we talk, it's like we are sharing your power. Let's stop it. It's not good for the country. It's not good for our image as parliament. And I protest. He says he's going to have his turn.
Honourable members, I do not think any rules of the House has been flouted. So I'll proceed to give the floor to the majority leader. Majority leader, you have the floor.
Thank you very much. Let me join some colleagues to congratulate my 1 year senior at the bar on your nomination to the Supreme Court. By way of follow-up question to what he has done, if a president appoints ministers and public officers and directs all of them to file their asset declaration forms with the Auditor General, and then further directs that when they have filed, they should send him the receipt. Because when you file with the Auditor General, they issue you with a receipt. And he further directs that when you file, forward a copy of the receipt to me so that I see that you have actually filed. If you don't send me a copy of the receipt, I will sanction you. If the president sanctions his appointees for not forwarding copies of the receipts to him, how is that, in your opinion, a usurpation of the functions of the Human Rights Commission?
Honourable nominee, you have the floor.
Honourable Chair, it is to me not a usurpation of the functions, and I have said so. Thank you.
Yes, Honourable Minority Leader, you may proceed.
Honourable nominee, now let me be very specific and pick your thoughts. General sanctions imposed by the president against his appointees for some stated misconduct, in my view, may be within his general powers as an executive president. However, my question to you is, would the president be acting within his constitutional powers, having in mind Article 287 of the Constitution, if he imposes salary fines on his appointees for failure to declare their assets, to impose salary fines?
Honourable Chair, as stated, I do not see that the president has usurped his powers. It is an administrative fine or sanction that he has imposed, and I think it is well within his rights.
To impose salary fines, correct? I mean salary fines. That was your general. I'm referring to the salary fines, the imposition of salary fines. That is the one I'm talking about. As for the general issue of not usurping the powers of Shraj, I've understood you, that he has the powers to administratively sanction. But I'm saying specifically on imposition of salary fines. Your thought on that?
The nominee has heard your question and has provided an answer. So,
Mr. Chairman,
Minority
yes,
Leader,
he's
kindly
provided.
ask another question.
I've heard the nominee on the issue of usurpation, and I'm not litigating that. What I am specifically narrowing on, which I want unambiguous view. She can say she's abstaining. Yesterday, some declined to answer. I won't pursue. I am asking whether specifically the power to impose salary fines, do you consider that to be constitutional? That is my specific question.
Honorable Chair, my position remains the same.
Very well, we move on. Now, my lady, how should the court view presidential actions that appear to preempt or substitute investigative and enforcement role constitutionally vested in Shraj under Article 287?
Can the question be clarified?
My lady, by way of clarification, and I would repeat the question and break it down so that I assist with some example to help. And I thank you for always seeking clarification. So the question is, how should the courts view presidential actions that appear to preempt or substitute the investigative and enforcement role constitutionally vested in Shraj? So, instances, now you're going to that all-important court, the Supreme Court. A matter comes before you, and on the face of the facts, you realize that there is a preemption, or the presidency or the executive has taken certain decisions that in itself takes away the powers of a constitutional body. As a court, having seen such a situation, what will be the reaction of the court? That is the point I want to know.
Honorable Chair, I believe that these matters will be determined based upon the evidence before the court and the issue placed before the court. So it's very difficult to make a general statement of how the court would react. So it would be dependent on the circumstances of each particular case. Thank you, Honorable Chair.
The accused person. I want to hear your thoughts on the rules of fair trial and bail conditions, which some of us deem too onerous in our opinions. Thank you.
Thank you very much, Honorable Chair. Well, the position of the law is that all offences now are bailable. And if an accused person is granted bail conditions, which he or she deems are onerous, you have the liberty to apply for a variation of your bail conditions. And if you find a stumbling block in that court, you can appeal against those conditions. Because the aim of the conditions is not to punish the person, but to ensure that you will make yourself available for trial. And that at the end of the day, if you should abscond, the sureties who have signed your bond would be able to meet whatever conditions are required of them. And so it is not supposed to be a punishment. So if you are unable to secure bail or the conditions are onerous, You either apply for a variation or you appeal so that the appellate court can take another look at it. Thank you very much, Honorable Chair.
Thank you, my lady. It will surprise you that you appear before a judge, and the mood of the judge will be that, oh, yes, I've refused your application. You can go up. Straight away. And without considering the merits of the application, say, okay, I've read and I'm refusing, you can go up. And you can easily tell from the court that the person wasn't minded to even listen to you or take into account the conditions that the judge was setting. And it becomes problematic because I was in court one day, the accused person had served his term, it was left with only 3 months, and the lawyer was making an application for for a variation of a certain order that the judge had made. He said, oh, no, I'm refusing it. You can go on appeal. The person was left with only 3 months, and it was within the judge's remit to consider the application before her. And it became some banter between the lawyer and the judge in open court. And those are some of the things that I believe that when you go for training, you can look into some of this. The temperament at the bench sometimes makes lawyers exchange, for want of a better word. Thank you very much, my lady.
Thank you very much, Honorable Chair. I believe that the JTI would take that into consideration and ensure that the appropriate training is done. Thank you.
My lady, on that note, I wish you the very best, and God bless you.